Thank you, listeners. We're back with you on the hotline. We do have On the Pulse with Public Health coming up in a moment. But I want you to have an appreciation of what is contained in this Integrity Commission report for 2023-2024, because the reporting year, the commission needs to, every year it has to put in a report before the 30th of June. And I want to read this for you. I want to read firstly the chairman's remarks and start with part of the executive summary, because I think part of the chairman's remarks, parts have been interpreted to mean that any call or any passing of information to the Integrity Commission, irrespective of the origin, sus, malice, or otherwise, then that information forms part of report, such as report of investigation into an illicit 6 or illicit 8, whatever the number is. But when one reads the executive summary, and indeed when one reads the law, then we'll see that it's not so much every call that comes in that becomes an investigation, but there's a sifting process that takes place by the Director of Information and Complaints, who does sort of a triage and reports up to the Director of Investigation if he's satisfied that there's more that an investigation can uncover about information that is given. So the chairman, the Honorable Mr. Justice Panton, retired, President of the Court of Appeal, retired, he says, during the past year, the Integrity Commission continued to do what it's established to do, commend the staff and so forth. In terms of ethics, Commission was established to promote and enhance standards of ethical conduct for parliamentarians, public officials, and others in keeping with this mandate. I couldn't understand what this is about. The Commission wrote to the Honourable Speaker in March of this year in respect of a statement made by a parliamentarian shortly after the municipal elections held in February. To date, there has not been acknowledgement of the Commission's letter. I should like to think this has been an oversight on the part of the Speaker, as I refuse to think that she deliberately ignore such an important communication. The Commission is watching to see what action will be taken. I would love to know what comment is it that was made and which the chairman wrote to the Speaker about. He speaks about staff. From time to time, reference is made to the sum of money voted by Parliament for the operations of the Commission. It needs to be stated, notwithstanding the budgeted amount, the fact is that the Commission's staffing is not at the desired level. This understaffing is due in part to restrictions imposed by Finance Ministry as regards the level at which the Commission can place an employee within the approved salary scales. Consequently, the Commission is at a disadvantage in the recruitment market. I need to find out from the Finance Ministry about this scale that restricts the employment of individuals to the Integrity Commission. But more importantly, I think the Integrity Commission has to get on quickly with the electronic system for verifying statutory declaration and assisting it, and it may not need as many people as it believes it needs, because technology will actually do the work faster without, the need for people to be sort of using a microscope to comb through some form submitted by handwriting. But I need to find out from the Ministry of Finance what that is about. So the legislation specifies that certain persons are to make annual declarations of their incomes, assets, liability, and it provides penalties for those who do not comply. Certain statutory posts called directors are created and powers granted to the holders thereof to make inquiries, conduct investigations, and prosecute where breaches occur. Acts of corruption, as defined by the Integrity Commission Act, also fall under the purview of the Commission. The Commission has an executive director responsible for day-to-day management of affairs of the Commission, other than those assigned to a director under the Act. The commissioners are to see the proper execution by relevant officers of the various tasks prescribed in the legislation. The law restricts the Commission from making any report or public statement in relation to the initiation or conduct of an investigation by the Director of Investigation prior to tabling a report in Parliament. Insofar as statutory declarations, government contracts, and prescribed licenses are concerned, the law states that every person having an official duty under the Act shall regard such matters as secret and confidential. Penalties of fines and imprisonment are prescribed for any breach. Given the state of the legislation, this is what media have been quoting, it is irritatingly unfair and unreasonable for persons, some of whom know better, to be questioning or requesting the Commission to speak on matters relating to statutory declarations or investigations. In my view, Jamaicans are quite low on the ladder of compliance as regards the various laws passed by Parliament. The Commission ought not to be, and indeed will not be, in such company. We await the amendments that we have suggested. Then the Commissioner, the chairman, says, of course, there's nothing preventing declarants or persons under investigation from speaking on the situation as it relates to them. Let me just say respectfully. In fact, I never preface a sentence with respectfully. And in fact, I'm going to take back never, because one must not engage in the practice of being so absolute. So I retract never, and I retract respectfully, because everything I say respectfully. If it comes across any other way, I beg you not to interpret it as such. I do not agree that there is nothing in the law that prevents persons under investigation from speaking. The statutory declaration, as I said, is not an investigation. An investigation is a different tier of action, specifically in the remit of the Director of Investigation. And from my interpretation of Section 53(3) of the Integrity Commission Act, in particular, but the whole thrust of Section 53, which deals with the secrecy of the investigation, I do not believe that those under investigation, if they know that they are statutorily allowed to say, if there's anyone who has, you see, the law, this particular law has not criminalized a person who is being investigated speaking out. And there's no need to do that. It's a stupid thing to do that. Because the reason for the protection under secrecy is to protect that individual. If the individual wants to rid himself of the protection to his own folly, then so be it. But it is my interpretation, even if another interpretation is possible, then I am of the view that if you're under investigation and if you know, having been told by the Commission, it is not something that the law countenances that you are to disclose. In fact, you may engage an attorney if you're told, and when you engage an attorney, privilege attaches to the communication between you and the attorney. And the attorney can't come disclose that information unless you authorize him to do so, which would go back to the first point. Yeah, but I respect the right of, anyone to have a different view, and what they former president of the Court of Appeal has said here is that, in his view, there's nothing in the law that stops somebody under investigation from speaking. I agree that in relation to the statutory declaration, nothing stops that individual from speaking. But having had a conversation here with Jeanette Calder concerning calls by the Prime Minister, the reason I said the Prime Minister cannot speak is on the basis of the discussion I had with her that they having delayed because of inability to supply, or whatever the reason, to supply the information to the Director of Information and Complaints to satisfy him on the bona fides of the information relating to statutory declaration. We were on the trajectory that 2-3 years, really too long for that sort of certification process to be going on, and the next step would be for the commission to a recommendation to be made to ratchet the matter perhaps up to the Director of Investigation, in which case a special report could be made in Parliament, and on the basis of that special report, the Integrity Commission could say little. And if that is the case, then the Prime Minister in law could not speak. Yeah, so that was the context of the conversation I had some weeks or months ago with Jeanette Calder. But the chairman of the commission went on in his report to speak on the Prime Minister's statutory declarations, and I find the language used here to be quite interesting. He says much has been written and said in respect of the certification of the PM statutory declarations. The Act makes special provisions for the statutory declarations of the PM and opposition leader. Hear what he says. The Director of Information and Complaints is required to examine their declarations, and where he is satisfied that it is duly completed, he is to inform the Commission. Upon being so informed, the Commission is to publish a summary of the statutory declaration in a form that is set out in the 3rd schedule of the Act. And I pause to tell you, this is examining. It is not an investigation, and the language of the law is explicit. And the chairman repeats the language accurately. There's one section of the law speaks of inquiries, but the law makes a distinction between inquiries and investigation. It must be remembered, says the chairman, that to satisfy himself of the due completion of a statutory declaration, the Director of Information and Complaints, quote, shall make such inquiries as he considers necessary. The inquiries are aimed at determining accuracy. Given the restrictions imposed by the Act as regards statutory declarations generally, and then he says, and matters related thereto, I may only say that the processes of the Commission are nearing completion in respect of the Prime Minister's declarations. And this particular language has had me wondering. Yeah? Given the restrictions imposed by the Act as regards statutory declarations generally, well, and matters related thereto, I may only say that the processes of the Commission are nearing completion in respect of the Prime Minister's declarations. We'll see. Then in terms of the obstacles now, the Director of Information and Complaints is empowered to make such inquiries as he considers necessary in order to certify or determine the accuracy of a statutory declaration. The Director of Investigation has a duty to investigate all allegation that involves or may involve an act of corruption or any allegation relating to non-compliance with the provisions of the Act. And guys, you need to know the difference between these two directors, their functions. Yeah? Inquiries, examinations, queries of statutory declarations, these are my words now, those are not investigations. Yeah? The person who does the investigation is the director of investigation, and that person has a duty, as quoted by the chairman directly from the Act, to investigate any allegation that involves or may involve an act of corruption or any allegation relating to non-compliance with the provisions of the Act. It should not be assumed that there is smooth going in the execution of these roles by the two directors mentioned. They face similar or significant resistance from time to time by some individuals as well as some institutions. Those who followed the proceedings in the court would have noted that the Commission had to go to the Supreme Court to get an order for Burrito Investments to comply with a request for information. Let me pause here, because I also hear the civil society groups latching on to this and, making call for there to be whatever sort of compliance and so forth. Listen, particularly because I practice in the civil courts, the provision surrounding even request for information, it's a provision that has had a whole body of case law around it. Yeah? Because certainly within the context of a claim, what one is asking for, one has to make out the direct relevance of the matter to whatever one is investigating. So I wouldn't read too much into an entity such as a financial entity initially resisting or desiring the court to make an order setting out in clear terms what exactly they're to comply with and what is to be given. Yeah, because sometimes it is the best way. You as the bank will have to try and safeguard yourself as well from any liability that one can accuse you of as the customer of the bank. So the fact that there's a provision in the Integrity Commission Act for banks to share this information doesn't mean that the banks shouldn't satisfy themselves on how it is that the information is to be shared, exactly what documents are to be disclosed, and a court can set out with some exactitude what is to be disclosed. And sometimes it's really probably to protect the institution from liability while the institution resists a request and seeks to defend the matter in court so the court can give an order. Yeah? So Burrito is singled out for failing to comply. The chairman says Burrito is not the only institution that has hesitated to comply with the Commission's legitimate requests. There is one other institution that has not been cooperative with as the Commission would have liked. I wish to use this medium to urge financial institutions to respond positively and truthfully when the Commission comes calling. It is unwise for them to endanger their licensees or their relationships with international or external bodies. As indicated in an earlier message, it cannot be business as usual. Delays in investigating matters are also caused by lawyers for declarants who seek multiple adjournments when the Director of Investigation has had occasion to summon a declarant for a judicial hearing. And this language is interesting. And again, you see how all the processes have to be intertwined, because whereas the Commission can request information. Each and every person who is summoned to come before the commission has a right to take an attorney. And if the attorney is not satisfied with whatever, to seek an adjournment to put himself or herself in a better position to have the person answer.